everybody doing? Great to be learning with you on a Monday. Let's light up the darkness. Who's in the house? Stephen in New Hampshire, Bill in Missouri, Shandor in the Bronx, Guy in Ohio, Paul in the Great Northwest, Lucy in Minnesota, Joseph in Massachusetts, and it skipped on me, and Carla in Brazil, and Ryan in Jacksonville, Bella in Florida, John in Maine, Melissa in Great Neck, Joe in the Inland Empire, Mark in Maryland, Nancy in North Carolina, Sharon in New Jersey. Joseph says, so strange in a good way. I was literally praying to Hashem to give me situational awareness a few days ago, and Sal mentioned verbatim last night. Amazing. You know, and I'm always saying it to my kids and my family. We cannot walk around in condition blind, especially not these days, not on our phones, not on the moon. We got to always maintain situational awareness for our safety. We just got to do it. Marjorie says shalom. Chaim in Florida. Ella says shalom. Aoife in Florida. Welcome, everybody. Also, Esther in Maine. Tonight's episode of AT Daily sponsored by our own Lisa Gilman for the healing of Jada C. I'm not going to, say people's full names, English names who need a healing, but we are thinking of Jada, last name, initial C. May she have a refuah shlema, a complete healing of mind and body, and may it be speedy, and we say amen. And Lisa, thank you so much for enabling us to share more Torah with more people around the world. May you and all your loved ones be showered in blessings. And we say amen. Very interesting daf tonight. Page 32 here in Tractate Bava Kamma. The 21st volume of the Talmud. We're continuing our discussion of Mishna number 6. Mishna number 6 here in chapter 3. We read the Mishnah at the end of yesterday's class. Basically, if two people are walking in the public domain, one is carrying a beam, right? So a long beam, a heavy piece of wood. The other one is carrying a barrel, or let's say a clay jug. And they collide. Okay, so if they were both walking in opposite directions, it's an accident. The owner of the beam is not liable to pay for the damage to the one carrying the clay jug. But if the guy with the beam, if they're walking in the same direction and the guy with the beam is behind and he runs into the jug and breaks it, then he is liable because he's behind. He can see what's going on ahead of him. However, if he's walking in a normal manner and he has some expectation that the guy with the jug who's walking ahead of him is walking in a normal manner and isn't going to stop short, and then the guy with the jug stops short and now the beam breaks the jug, so the owner of the beam is exempt, not liable. Likewise, if the one with the jug is walking behind and he runs into the beam, the owner of the beam not liable. But if the guy holding the beam stops short and the guy with the jug runs into him, liable, right? Because if you act in an irregular, unforeseeable way that leads to the accident and you didn't give a warning when you could have given a warning, these are some of the nuances and variations on the story that lead to liability. So that's basically the Mishnah. Here comes the Gemara. Now the Gemara starts by going to a completely different and unexpected place. Says the Gemara, Rabba Bar Nassan asked Rav Huna, with regard to one who causes injury to his wife during sexual intercourse, what is the law? Is he liable to pay damages? Is it reasoned that since he is acting in a permitted manner, he is exempt? Or perhaps he should pay attention and be more careful? There seems to be a lot of facts missing here. I mean, normally, right, when husbands and wives make love, nobody gets injured. So something was going on here that led to an injury. And the reason they're bringing this case is because one of the nuances and variations that we've been talking about in the cases of causing damage in the public domain or in a private domain, as we'll see later. There's a big variation or big question to ask. One of the elements of liability, as it were, is, did both parties have permission to be there? If one didn't have permission to be there, how is that going to affect liability? So here what they're saying is, well, the husband is not permitted to have sex with any other woman in the world, but he is permitted to have sex with his wife. So now that he's doing something which is permitted, right? And we've also seen there's a distinction between being permitted, like when we're talking about dumping your sewage in the street during the rainy season. This is permitted. Nevertheless, if you dump your sewage in the street during a permitted time and it causes harm to somebody, you are liable to pay. But, and this is very good, appropriate for this week, if you put your Hanukkah lamp out there in the public domain, whereas normally you're permitted to use the public domain, but not to put a hazard out there like an exposed oil lamp that could cause a fire. If, say, an animal walks by with some flax on its back and it catches fire, and then maybe it spreads the fire and a house burns down. So if you put this exposed burning lamp, oil lamp, in the public domain, it leads to a fire, you're going to be liable. But during Hanukkah, you're not only permitted to do that, you're permitted to do it for the sake of a mitzvah. And therefore, you're not liable in that chain of events that leads to a fire. So here, they don't even mention this in the discussion, but a husband is not only permitted to make love with his wife, but, right, normally husbands and wives are making love. There's at least a possibility, at least for, part of their married life, to produce children. And that certainly is a mitzvah for the man, right? For the man. Women are not obligated to have children. We've learned this before. They're not obligated to have children because there is a certain danger in childbirth. And so if a woman doesn't want to have children, she's not obligated to do so. A man is obligated under Jewish law to have children, right? And according to Beis Hillel, he fulfills that obligation when he's fathered a son and a daughter. According to Beis Shammai, 2 sons. So here, the husband is making love with his wife. He's fulfilling a mitzvah. Now, they don't actually talk about this permission and fulfilling a mitzvah. Right now, they're just talking about, but he's permitted. He has permission to do this. So if she gets hurt, right now, we're going to assume that he's not intentionally hurting her. This is not some kind of rough sex thing. It's an accident, right? It's an accident, but it's an accident that arose from his force. So perhaps he was negligent, right? He got carried away or something, and in some way she was injured. So let's keep that in mind as we read. Right. So Rabba Bar Nassan asked Rav Huna, with regard to one who causes injury to his wife during sexual intercourse, what is the law? Is he liable to pay damages? Is it reasoned that since he is acting in a permitted manner, he is exempt? Or perhaps he should pay attention and be more careful. So Rav Huna said to Rabba Bar Nassan, you learned this law in the Mishna concerning one person walking with a crossbeam and another with a barrel. Interesting. Which rules that the owner of the crossbeam is exempt. Why? Because this one had permission to walk and that one had permission to walk. Similarly, the husband has permission to engage in intercourse with his wife. If he injures her in the process by accident, he is exempt. Rava disagreed with Rav Huna's opinion, and he said the husband is liable due to a kal v'chomer inference from the law with regard to manslaughter. We're going to look at the area of law about manslaughter, right? So manslaughter is a type of homicide that is distinguished from murder, right? Murder is when you kill somebody with intent. Manslaughter is an accident that's not really an accident, right? In other words, because you were negligent in some way, you end up killing somebody. So the Torah says that in that case, and the example that's actually given in the written Torah, is the one who is chopping down a tree, and he, moves his axe back, and because he didn't check his surroundings, because he didn't have situational awareness, on his backswing, he hits some poor guy in the head and kills him. That's a sort of classic manslaughter situation. And the Torah says about this man that he is exiled. His punishment is exile. Exile to where? To a city of refuge, right? That the Torah established, during the initial period of Israel having sovereignty in the land of Israel, that there would be cities of refuge where the manslaughter could go. And this would be to save him from the avenger of blood, meaning the kind of blood feud that would result between two families when, one guy negligently kills another, so the relatives will come and kill him. But they do not have permission to do that in the city of refuge, and the exilee, the manslaughter, must remain in that city of exile. And this is a little bit tough break. It's not for a certain number of years. It's until the present high priest, the Kohen Gadol, dies and is replaced by a new high priest. Could be a day, could be a week, could be a year, could be a decade, could be more. He doesn't know. Okay, so we're going to borrow from that area of law to analyze this case of the husband who accidentally hurts his wife when they're making love. So how does this work? So it's a kal vachomer inference based on the law of the manslaughter. So Deuteronomy 19:5. As when a man goes into the forest with his neighbor to chop wood, and the head slips off the helve. Okay, so the head of the axe actually flies off the axe handle and finds his neighbor, and he dies. So he shall flee to one of these cities and live. And just as in the forest, where this person enters his domain and that person entered his domain, as it is the domain of the public, and nevertheless, the one who kills unintentionally is considered like one who entered another's domain and is therefore liable to be exiled to a city of refuge, then with regard to this husband who actually enters another's domain, and he means he enters his wife, so all the more so is it not clear that he should be liable for the injury that he causes her. So the Gemara raises an objection to Rava's opinion. But what of this Mishna, which teaches that the owner of the crossbeam is exempt, as he and the owner of the jug both had permission to walk in the public domain. So they had an accident, but he didn't do something wrong, so he's exempt. Why are we going to hold the husband liable when he didn't mean to hurt his wife? It was an accident. And they were both permitted to be there. And, specifically, he was permitted to be there doing what he was doing. So the Gemara answers, no. The two cases are different. There, in the case of the Mishna, both sides were similarly walking. And the one who caused the damage is therefore exempt due to his right to walk there. By contrast, here, the husband is the only active participant in the intercourse. Therefore, since he is the one performing an action, he is liable even though he is acting with permission. Our modern ears perk up, but we're not so modern. The Gemara's ahead of us. And the Gemara asks, and is she, the wife, not considered an active participant? But isn't it written with regard to forbidden sexual intercourse? Quote, even the souls that do them shall be cut off from among their people. Meaning that if a man and woman commit some kind of prohibited sexual act, like for example, incest, okay, so they are both blamed for it and they are both punished for it. Not just he, because she's some kind of passive participant. They are both active participants. So how can you say that this husband is the active participant and his wife is not? Indicating that both the man and the woman are considered to be performing an action. So the Gemara answers, that verse is referring to the fact that they both have pleasure from the act. The woman's pleasure is tantamount to active transgression, and she is therefore punished if she participates willfully in a prohibited sexual act like adultery or incest, etc. But with regard to this injury that a wife sustains from her husband making love, well, he is the one, for these purposes, who is considered to be performing the action that led to her injury, and he is therefore liable. So where did this law end up? One who causes injury to his wife during intercourse is liable to receive punishment for her injury, in accordance with the opinion of Rava, who is the later authority than Rav Huna. And this includes compensation for damage, pain, medical costs, and loss of livelihood. He is exempt, however, from compensating her for humiliation, since he did not intend to humiliate her. Hopefully, husbands and wives are not carrying on in a way that leads to injury. And presumably if some minor injury ensues, they're going to probably keep it to themselves. Perhaps what we're talking about here in this set of facts is more of a hypothetical, trying to understand how permission affects liability. Or perhaps it's a set of facts that, really has a lot more drama and story going on. But at any rate, that's where the discussion about that question ends. Now we return to the subject of the crossbeam and the jug. So the Mishna teaches, in a case where the owner of the crossbeam was walking first and the owner of the barrel was walking behind him, if the barrel was broken by the crossbeam, the owner of the crossbeam is exempt because the one with the barrel was walking forward and he ran into the guy with the crossbeam. He should have seen it and avoided it. Reish Lakish says, if two cows were in the public domain, one of them prone and one of them walking, and the cow that was walking kicked the cow that was prone, its owner is exempt. Why? Because the cow that was lying down in the public thoroughfare, that's not a good place for it to be lying down. Obviously, people are going to walk by. It's going to cause problems if it's blocking the road. And because it's in this irregular place, if it ends up getting kicked by somebody's cow that's walking by, the owner of the walking cow is exempt. Whereas Reish Lakish also told us that if the prone cow kicks the walking cow, now the walking cow is, doing what cows do in the public thoroughfare, just walking by. The prone cow, really doesn't matter whether it's prone or not, it's just the continuation of the same concept. Any cow that kicks another cow in the public domain, this is likened to goring, right? Kicking is an unusual act for an animal to do. It's doing it for the purpose of hurting another, like goring. So if it's not a cow that's known to kick, its owner is going to be liable for half the damage that it causes when it kicks another cow. And if it's known to be a kicking cow, a muad kicking cow, then its owner will have to pay the full value of the damages. So continuing, Reish Lakish says, if two cows were in the public domain, one of them prone and one walking, the cow that was walking kicked the cow that was prone, its owner is exempt. If the prone cow kicked the one that was walking, the owner is liable to pay. Let us say that our Mishnah about the guy with the beam and the guy with the barrel supports this statement of Reish Lakish. As it states, if the owner of the crossbeam was first, he was walking in front, and the owner of the barrel was last, and the barrel was broken by the crossbeam, the owner of the crossbeam is exempt. But if the owner of the crossbeam stopped, the owner of the crossbeam is liable, meaning he stopped suddenly and the guy with the barrel ran into him. So the Gemara explains its proof. But here it is clear that it is like a case where the prone cow kicked the cow that was walking, since the one carrying the barrel was walking and the one carrying the crossbeam stopped, right? And it was like the prone cow. And the one carrying the crossbeam stopped in the public domain, causing damage to the one walking with his barrel. And the Mishnah teaches in this case that the owner of the crossbeam is liable, right? So it seems to support Reish Lakish's view that the prone cow kicks the walking cow. The owner of the prone cow is liable. Just like if the guy with the crossbeam stops short and the guy with the barrel walks into him, the owner of the crossbeam is liable for breaking that jug. Are they analogous, parallel cases that we can learn, we can sort of apply the law of one to the other back and forth? The Gemara responds, and how can you understand that reasoning? You wanted to support the statement of Reish Lakish from our Mishnah? Not only does it not support Reish Lakish, it even raises a difficulty to his opinion. The reason Reish Lakish stated that the owner of the prone cow is liable is that it kicked the walking cow. But if the walking cow was damaged because by itself it collided with the prone cow, he would be exempt. But our Mishnah discusses a case where the one carrying the barrel ran into the crossbeam by himself without the one carrying the crossbeam actively hitting it. So how can you compare that to a prone cow that kicks? And it teaches that the owner of the crossbeam is nevertheless liable. So the Gemara explains our Mishnah is referring to a case where the crossbeam blocked the entire width of the road like a carcass. Since the one carrying the barrel could not avoid it, the one carrying the crossbeam is liable, although he did not actively break the barrel. By contrast, here, Reish Lakish's statement is referring to a case where the cow was lying down on one side of the public domain, and the other cow should have walked on the other, unobstructed side. Therefore, if the damage is caused only as a result of their collision, the owner of the prone cow is exempt, right? When we first discussed Reish Lakish's holding about this prone cow and the walking cow, it was really only about whether one of the cows was behaving in a typical or atypical manner. Now we're reading in additional facts. Is one of them obstructing the thoroughfare? Does the one that's coming along have an option to go around, or does he not have an option? And we see how additional facts can certainly affect the outcome, the legal ruling. So the Gemara suggests, rather, it is the latter clause of our Mishnah that supports Reish Lakish's statement. As our Mishnah teaches in its latter clause, conversely, if the owner of the barrel was walking first, and the owner of the crossbeam was behind him, and the barrel was broken by the crossbeam, the owner of the crossbeam is liable, because he was walking with this big hazardous object. He saw the guy with the barrel ahead of him, and he ran into him anyway, and broke the barrel. That's why he's liable. But if the barrel stops short, the guy with the barrel stops short, and that's why the guy with the crossbeam ran into him, then the owner of the beam would be exempt. But let's keep reading. That's right. So what they're saying, the Gemara is saying now, it's that latter clause when the guy with the barrel is walking in front. This is what supports Reish Lakish's statement. As it teaches, conversely, if the owner of the barrel is walking first and the owner of the crossbeam last, and the barrel is broken by the crossbeam, the owner of the crossbeam is liable. But if the owner of the barrel stopped short, the owner of the crossbeam is exempt from liability for breaking the barrel. But here, it is clear that it is like a case where the walking cow kicked the prone cow. And the Mishnah teaches that the owner of the crossbeam is exempt, lending support to Reish Lakish's ruling. But the Gemara rejects this suggestion. In other words, these two areas of law, they're not parallel enough for you to even say that one lends support to the other because they're so different. And the Gemara explains, the Mishnah, our Mishnah about the beam and the barrel, exempts the one carrying the beam because he was walking in his normal manner when he hit the barrel. Here, perhaps the owner of the prone cow can say to the owner of the walking cow, although you have permission to walk over me, i.e. for your cow to walk over my cow, you have no permission to kick me, i.e. for your cow to kick my cow. And that's it. That concludes our discussion of Mishnah number 6. But I think the important lesson there, always, when you're trying to apply one kind of law and legal ruling to another area, and it seems like the analogy works, you got to test the analogy because it might not bear scrutiny as we apply additional facts. Mishnah number 7. With regard to two people who were walking in the public domain, or one who was running and another one was walking, or who were both running, and they damaged one another, both of them are exempt. Okay, now we're talking about people colliding in the public domain. We're asking whether they're acting in a typical or atypical manner, but now we're going to remove their objects. No beam, no barrel. They just run into each other. Okay, so now we have 3 cases, or I guess 4 cases there would be. One is walking, one is running. Both are running, both are walking. Presumably, if both are walking, there's not going to be a collision. They could be coming around the corner, but in all these cases, No one's liable because they just ran into each other. Okay, so it's an accident. Nobody was doing anything so bad. Or were they? Here's the Gemara. The Gemara comments, the Mishna, right, which says that they're all exempt, right? Two people were walking, or one was running and one was walking, or both were running. If they damage one another, both of them are exempt. Okay, no one liable. Here's the Gemara. This Mishnah is not in accordance with the opinion of Issi ben Yehuda. As it is taught in the Baraisa, Issi ben Yehuda says that one who runs in the public domain and causes damage is liable to pay for any damage he causes because his behavior is unusual in the public domain. I am ashamed to recollect that when I was in junior high, it was a game that some of my buddies and I had. We went to a very large junior high, and it was a long walk from the dining room back to where the classrooms were, down a very long hallway that was often crowded with people. And we thought it was such a fun and funny game to run as fast as possible through that crowd of people. I mean, it wasn't a mob. People were generally walking, but it was like weaving in and out of people and running as fast as we could while weaving in and out. It was so much fun. We're idiots. We were 13-year-old idiots, and thank God we didn't, hurt anybody. But obviously, if we were running at that speed and we misjudged a gap that we were running between, or somebody just suddenly stepped to the side because he didn't want to, step on gum or something, and we collided into that person at high speed, or, perhaps an older teacher, we could have really hurt somebody. And of course it would have been our fault, right? Obviously, if you're running where other people are walking, you're creating a hazard per the ruling of Issi ben Yehuda. So how is it possible that our Mishnah says that if people are running, or one is running and one is walking, and they run into each other in the public domain, everyone's exempt? Why? Why isn't the law like Issi ben Yehuda? Must be we're missing some facts. Issi ben Yehuda says that one who runs in the public domain and causes damage is liable to pay for any damage he causes because his behavior is unusual in the public domain. And Issi concedes with regard to one who runs and causes damage at twilight on the eve of Shabbos. That person is exempt. Why? Because he's running with permission, right? He's running to, get to where he's going to be for Shabbos and begin the piece of Shabbos. And probably he's got some last minute things that he's got to do for the purpose of making Shabbos beautiful and comfortable. And he's not going to be able to do that thing after Shabbos begins. Like, for example, lighting candles in his house, or lighting a torch right before Shabbos begins, because if he doesn't do that, he's going to sit in the dark on Shabbos, since he can't light it after Shabbos starts. So you have permission to run in the streets when Shabbos is approaching. So Rabbi Yochanan says the law is in accordance with the opinion of Issi ben Yehuda. And the Gemara asks, and did Rabbi Yochanan actually say this? That if one runs and causes damage, he is liable? But doesn't Rabbi Yochanan say, as a principle, that the law is in accordance with an unattributed Mishnah? And our Mishnah, unattributed, right? Anonymous Mishnah, usually that means it's Rabbi Meir's holding. But the point is, an unattributed Mishnah is understood to be an authoritative Mishnah. And that's Rabbi Yochanan who said that. The law always accords with an unattributed Mishnah. And our Mishnah said, if somebody's running and somebody's walking and they collide in the public domain, they're exempt. Both are exempt. So why is Rabbi Yochanan himself, who says we follow unattributed Mishnahs, now saying, but not this unattributed Mishnah? Here the law accords with Issi ben Yehuda. Why? But doesn't Rabbi Yochanan say as a principle that the law is in accordance with the unattributed Mishnah? And we learned in the Mishnah that if one was running and the other was walking, or they were both running, they're exempt. So the Gemara answers, the Mishnah, which exempts one who was running, is referring to twilight on the eve of Shabbos, when people are permitted to run in the public domain. That's the information that our Mishnah was missing. You can do that and be exempt if you're doing it with permission. And when are you permitted to run in the public domain? When you're running to prepare for Shabbos. So the Gemara explains, from where is it inferred that the Mishnah is referring to twilight on the eve of Shabbos? Is that the only time when the Mishnah's ruling is valid and the rest of the week it's not? It is inferred, so how do we know this? Because that is the ruling. It is inferred from the fact that it teaches or who are both running. They are, when the Mishnah says or who are both running, they are exempt. Why do I need this case as well? Now that the Mishnah teaches that if one was running and the other was walking, that the one running is exempt, is it necessary to state that he is exempt when both of them were running? Rather, this is what the Mishnah is saying. If one was running and the other one was walking, he is exempt. In what case is this statement said? It is said with regard to twilight on the eve of Shabbos, when running in the public domain is permitted. But on a weekday, if one was running and the other one was walking, the one who was running is liable. If both were running, even on a weekday, they are exempt. And this emendation to our Mishnah explains the need to mention the case where both were running. So the master said above, an Issi concedes with regard to one who runs and causes damage at twilight on the eve of Shabbos that he is exempt because he is running with permission. So the Gemara asks, what is the reason that running at twilight on the eve of Shabbos is considered to be with permission? I said it's because he's running to do a mitzvah so that Shabbos will work, and that's the permission. Let's see what the Gemara says. And the Gemara answers, it is like that which Rabbi Hanina would say. As Rabbi Hanina would say, at twilight on the eve of Shabbos, come and let us go out to greet the bride, the queen. Lecha Dodi, right? Lecha Dodi was actually a song that was composed in Sfat in the 1500s. But we see that this about going out to meet the Sabbath bride. But you see that this tradition goes much further back than that. It's here in the Gemara, so it's at least 1,500 years old. So come, let us go out to greet the bride, the queen. And some say that this is what he would say. Come and let us go out to greet Shabbos, the bride, the queen. And Rabbi Yanai would wrap himself in his talis, in his prayer shawl, and stand at the eve of Shabbos at twilight, saying, come, bride, come. Similarly, it is appropriate for one to run out in honor of Shabbos. So interesting, right? It's not just that you're running to do those last-minute mitzvahs to get your house ready for Shabbos, but that you're literally standing up and going out and even running to meet and to greet Shabbos, right? Like you have to be so excited, like a celebrity is coming, or even more, like the bride at a wedding. And here's the note from Rav Steinsaltz, citing the Maharsha. The Maharsha writes that Rabbi Hanina would act as one would upon receiving a king by going out to greet him. Whereas Rabbi Yanai would act as a groom waiting in place for his bride to come to him. From the wording of this law in the Mishnah Torah and Shulchan Aruch, it appears that receiving a king has the connotation of seriousness, whereas greeting a bride and bridegroom connotes joy. And that's why that is the custom that is taken over. And says Rav Steinsaltz, this is the source for the custom to stand during the Kiddush ceremony on Friday nights, as people customarily stand in honor of the bride. And Shabbos is termed the bride of the Jewish nation. Now, some have the custom to sit during Kiddush because they relate to Shabbos as the queen of the Jewish people, in accordance with Rabbi Hanina's custom, and a king is not required to stand for his queen. But I think most people do have the custom to stand for Kiddush. We certainly do. And so when you stand for Kiddush at your Friday night, Shabbos dinner, and you sing a song, and then you sing a few songs, you bless the children, you sing Eshes Heil for the lady of the house, and then everybody rises, right? And we lift the cup of wine, and we make Kiddush. We sanctify Shabbos by saying a blessing over the wine, and we all stand for that. And it's not just that we're standing to say an important mitzvah, it's that we're literally standing the way people stand at a wedding when the bride comes up the aisle. That's how we sort of picture Shabbos. We are on page 32b. That concludes our discussion of Mishnah number 7. Here's another Mishnah, number 8, here in chapter 3. With regard to one who was chopping wood in the public domain, and a chip flew off and caused damage in the private property of another person. Or one who was chopping wood on his private property, and he caused damage, a chip flew into the public domain. Or one who was chopping wood on his private property, and the chip flew off into somebody else's private property and damaged a person. In all these cases, he is liable. You're chopping wood, a chip of wood flew off. Whether you're in the public domain and the chip went to the private domain, or you're in the private domain and the chip went to the public domain, or you're in the private domain and it flew off and hit somebody in his private domain, in all these cases, you're liable. That's the Mishnah. And the Gemara comments, and it is necessary for the Mishnah to teach that he is liable in all 3 of these cases, because in each one there is a novel element. As if it had taught only the case where one was chopping wood on his private property and he caused damage in the public domain, it might have been reasoned that he is liable despite the fact that he was working on his own property, because it is common for the multitudes to be there in the public domain. And if his chip flies into the public domain, it's foreseeable that it could hurt someone. But if a chip flew from the public domain onto somebody's private property, where it is not common for multitudes of people to be, you might have thought that he is not liable. Therefore, the Mishnah teaches us that he is. And conversely, if it had been taught that he is liable where the chip flew from the public domain into somebody's private property, it might have been reasoned that he is liable because at the outset, he was acting without permission because he was chopping wood in the public domain. He has no right to do that. But if it flew from his private property to the public domain, since he does have permission to chop wood on his own property, you might have thought that this flying chip would not render him liable when it hurts someone in the public domain. Therefore, the Mishnah teaches us that he is liable. And if the Mishnah had taught us only that he is liable in these 2 cases where a chip flies either from the public domain to the private domain or from a private domain to the public domain, you might have thought, and if the Mishnah had taught only that he is liable in these 2 cases, it might have been reasoned that in this case, where the damage was caused in the public domain, he is liable because it is common for multitudes of people to be there. And in that case, where he was chopping in the public domain and the chip flew to the private domain, he is liable because he was acting without permission by chopping in the public domain. But in the last case, where the chip flew from his private property to somebody else's private property, where neither of the above reasons applies, as it is not common for multitudes of people to be on someone's private property, and where he had permission to be chopping wood on his own property, you might have thought that he is not liable. Therefore, the Mishnah has to teach all 3 cases. The sages taught, Tosefta 625, with regard to one who entered the workshop of a carpenter without the latter's permission, right? Without the carpenter's permission, and a chip of wood flew off and hit him in the face and he died. The carpenter is exempt. Carpenter has every right to be working in his woodshop. He doesn't know that somebody's going to barge in without permission. So if a chip flies off and hits that person in the face and even kills him, the carpenter is exempt. But if the person who enters the wood shop has the carpenter's permission to be there, and now the carpenter, chops wood or saws, whatever, works his wood in such a way that a chip flies off and hits this person in the face and hurts him, now the carpenter is liable, right? Because it's on him to make sure that no permitted visitor in his wood shop is going to be hurt by the work that he does there. And the Gemara asks, what does the Baraisa mean when it rules that the carpenter is liable? And Rabbi Yosef Bar Chanina says, if the other person was injured, he is liable to pay 4 types of indemnity that the one who injures another must pay: pain and suffering, medical costs, loss of livelihood, etc. These are cost of damage, pain, medical costs, and loss of livelihood. But if the one who entered was killed, then the carpenter is exempt from exile. Remember, exile is the destiny of the woodchopper whose axe head flew off the handle and killed somebody in the public domain. Perhaps he should have been more careful. He should have maintained his axe better. He should have made sure that that head wouldn't fly off, right? So, that's why he's considered a manslaughter and not just an accident, which would not lead to exile. Right? And so the Gemara explains that the carpenter here, whose wood chip, injured somebody who was in his wood shop with the carpenter's permission. So why is this not like the axe head flying off the handle in the woods? And the Gemara explains that the carpenter is exempt from exile because this case is not similar to the case of a forest, which is the archetypal case stated in the Torah, requiring one who kills unintentionally to be exiled to a city of refuge. As it is written, and when a man goes into the forest with his neighbor to chop wood, and his hand fetches a stroke with the axe to cut down a tree, and the head flies off the handle and finds his neighbor, and the neighbor dies. Now this is because in the case of the forest, both this one entered his domain and that one entered his domain, meaning both were in the public domain where they had a right to be there. Whereas in this case, the victim entered the private domain of the carpenter. Therefore, the carpenter is not exiled, meaning exile is not good enough for him. It's not enough of a punishment, right? The carpenter is more liable. Excuse me. The carpenter is more liable. He has more liability than the woodchopper would in the forest. Excuse me. And Rava said, on the contrary, it can be inferred by a kal v'chomer inference that he is exiled. And like this, and if in the case of the forest, where this one entered of his own accord and that one entered of his own accord, neither asking for the owner's permission, nevertheless the victim is considered like one who entered with the other's consent, and therefore the one who kills unintentionally is exiled. All the more so is it not clear that in this case where the victim entered another person's workshop with his consent, that the carpenter should be exiled. Rather, says Rava, what is the reason? Right? It's not that he disagrees with the outcome, he disagrees with the reasoning. Says Rava, what is the reason that the carpenter is exempt from exile? Because exile is not sufficient for him. And this is the reason of Rabbi Yosef Bar Chanina, who exempts him from exile, because it is an unintentional killing that is approaching intentional manslaughter. The purpose of exile is to atone for one who kills another completely unintentionally, right? His axe head flew off his handle. Maybe he was negligent how he maintained his axe, but he certainly had no intention to hurt someone. But if he was exceedingly negligent, then exile is not sufficient to atone for him, right? If he had been warned, for example, hey, your axe is loose, that thing could fly off at any minute, and there were witnesses to that warning, and then he went to chop wood and the axe handle flew off, then that sounds like it would be more like, right, an unintentional killing that approaches intentional manslaughter, in which case the woodchopper would not have the protection of the city of refuge. He wouldn't be exiled. He would have to be, tried, and there'd be a trial. It might be a murder trial. It might be a damages trial. But the city of refuge and exile would not apply to him because that only applies for the purely unintentional killing. Now, Rava raises an objection to his own explanation from a Mishna. If one is sentenced to be flogged in court, And the doctors assessed that he would be able to endure only a certain number of lashes, but the one administering the lashes added one lash to this punishment, and then the one being lashed died. So then the agent of the court, right, meaning the one administering the lashes, is exiled on account of him. But here it is clear that it is a case of an unintentional killing that is approaching intentional manslaughter, as it should have entered his mind that people can die by one additional lash. And the Tana teaches that the agent of the court is nevertheless exiled. So Rav Shimi of Nehardea said in response, it is a case where he erred in the counting, which is not considered approaching intentional manslaughter. Right? So you see now they're definitely getting into the nuance of, okay, he didn't mean to kill, but to what degree was he negligent? A woodchop, I mean, like a carpenter in his own woodshop, where an accident results, you say, well, he's the master of his woodshop, right? So any accident that happens there is gonna be his fault. But here, the agent of the court, who's told by the judge, give lashes, okay, and he miscounts, was he really being negligent or was he not? Two sides to that argument. Now, Rava slapped Rav Shimi on his sandal, which is a gesture of disparagement, and said to him, is that to say that the one administering the lashes is the one who counts them? That's not how it works in a rabbinic court. But isn't it taught in a baraisa that the eldest of the judges recites the verses that are read to a person while he receives lashes, and the second judge does the counting, and the third one says to the one administering the lashes, strike him. They are very careful that there is not one extra or one missing lash, because they go through a whole process to make sure that no mistake like that gets made. So accordingly, it is not the one administering the lashes who errs in counting. If somebody made a mistake in counting, it would be one of the judges. So rather, Rav Shimi of Nehardea said it is a case where the judge made a mistake in counting, and the one administering the lashes did not notice the error and meted out an extra lash, causing the person to die. So it is therefore considered a completely unintentional killing. Consequently, he is exiled. Isn't that an accident which wouldn't even require exile? The Gemara raises an objection from another Mishna with regard to one who throws a stone into the public domain and kills someone. He is exiled. But here it is clear that it is a case of an unintentional killing that is approaching intentional manslaughter, as it should have entered his mind that people are commonly found in the public domain. And the Tana teaches that he is exiled, right? A guy who throws a rock out onto the street and ends up killing somebody, like, obviously that's total negligence. How could he receive the protection of exile to the city of refuge? He should definitely have some kind of a murder trial or be liable for damages, not, exile to the city of refuge. So Rav Shmuel Bar Yitzchak said, it is not a case where one threw a stone into the public domain for no purpose, but rather where he demolishes his wall, which borders on the public domain, and stones fall into the public domain. Therefore, is not considered to be approaching intentional manslaughter. Okay, he made a mistake, but he wasn't just throwing rocks in the street, for fun, and then, and then somebody dies. This guy was just doing an honest job. He was demolishing his wall, and an accident happened and someone was killed. Now the Gemara questions this assertion. Nevertheless, he should have paid attention to see if there was anyone there before he demolished his wall. And therefore it should be considered an unintentional killing that approaches intentional manslaughter. And the Gemara answers, it is a case where he demolishes the wall at night. So he has some expectation that nobody will be in the street. So the Gemara asks, even at night, he should also have paid attention to see if there was anyone there. And the Gemara suggests an alternative interpretation. It is a case where he demolishes his wall during the day, but into a garbage dump where people are not commonly found. So the Gemara says, what are the circumstances of this garbage dump? If it is a garbage dump where the multitudes are commonly found, it is considered intentional manslaughter. And if the multitudes are not commonly found there, he should be considered not only one who kills unintentionally, but a victim of circumstances beyond his control, since he could not have anticipated that someone would be there. Therefore, he should be exempt from exile and all charges. Rav Papa said this law is necessary only in the case of a garbage dump where people are given to relieve themselves at night and are not given to relieve themselves during the day, as it is near the public domain. But there are those who chance by and sit there for this purpose even during the day. On the other hand, he is not, on the one hand, the one who demolishes his wall, he is not one who kills intentionally, as people are not given to relieve themselves there during the day. On the other hand, he's not a victim of circumstances beyond his control either, as there are those who chance by and sit there sometimes. Therefore, he is considered one who kills one who kills unintentionally, but is a manslaughterer, and therefore he is liable to be exiled. Rav Papa taught in the name of Rava that this aforementioned statement of Rabbi Yosef Bar Chanina is in reference not to the latter clause of the Baraisa, but is in reference to the first clause. With regard to one who enters the workshop of a carpenter without permission, and a chip flies off and strikes him in the face and dies, the carpenter is exempt. He had no reason to know that somebody was entering his shop. The guy came without permission. And it is in reference to this clause that Rabbi Yosef Bar Chanina says, if the one who entered was merely injured, the carpenter is liable to pay 4 types of indemnity. But if the one who entered was killed, he is exempt from exile. And the Gemara comments with regard to the one who teaches this statement in reference to the last clause of the Baraisa, where one enters with permission, all the more so would he teach it as referring to the first clause, where one enters without permission. But the one who teaches this statement in reference to the first clause teaches it only in reference to that clause. But in the case of the last clause, since he entered with permission, the carpenter is liable to go into exile. And the Gemara asks, but is he liable to go into exile when the victim had permission to enter? But isn't it taught in a Baraisa that with regard to one who enters the workshop of a welder and sparks fly off and strike him in his face and he dies, the welder is exempt? And this is the law even if the victim entered with permission. Pause. When I read that, I was like, welder? 1,500 years ago? Welder? I'm amazed. Like, I always thought welding, like you need those high pressure tanks, a acetylene torch, super hot flame, melt steel to attach other steel, two pieces of steel to each other. I mean, I get they had blacksmiths 1,500 years ago or more, but they had welders? That's fascinating to me. Let's keep going. Where am I? Where's the welder? Yeah, but isn't it Tana Baraisa that with regard to one who enters the workshop of a welder and sparks fly off and strike him in his face and he dies, the welder is exempt? And this is the law even if the victim entered with the welder's permission. And the Gemara answers with, what are we dealing here in this Baraisa? So we're dealing with the welder's apprentice who enters his workshop. So the Gemara asks, does the welder's apprentice stand to be killed? I.e., it is permitted to kill him? The Gemara answers, it is a case where his mentor is urging him to leave, but the apprentice doesn't leave. The Gemara asks, and because the mentor is urging him to leave, does he stand to be killed? The welder should be careful until his apprentice leaves. The Gemara answers, the welder thought that the apprentice had already left when the accident happened. The Gemara asks, well, if so, why establish that the Baraisa refers specifically to an apprentice? The welder would be exempt if it were any other person also. And the Gemara answers, and now we're at the top of 33a, another person does not have awe of his mentor. Therefore, even if the welder urges another person to leave, he must ascertain that that person actually did so. And otherwise, he is liable to be exiled. By contrast, this apprentice has awe of his mentor, and so the welder may assume that if he instructed his apprentice to leave, that the apprentice left. Therefore, if in reality the apprentice did not leave and is killed by the sparks, the welder is not liable to be exiled, as he is not held accountable because he had a reasonable expectation that his apprentice would have left when he was told to. Rav Zevid taught in the name of Rava that this aforementioned statement of Rabbi Yosef Bar Chanina is in reference not to the above Baraisa, but is in reference to this Baraisa. It is stated in the verse concerning one who kills unintentionally, and the head slips off the handle of the axe and finds his neighbor, he dies. So this serves to exclude one who introduces himself into an area of danger, in which case the one who kills unintentionally is exempt from exile. From here, Rabbi Eliezer ben Yaakov says, with regard to one whom a stone departed from his hand, and another person stuck out his head and received a blow from it and died, the one who threw the stone is exempt from exile. It is in reference to this statement that Rabbi Yosef Bar Chanina says he is exempt from exile for killing him. But if the victim was merely injured, he is liable to pay for the 4 types of indemnity. And the Gemara comments, the one who teaches this statement to reference to this Baraisa, all the more so he would teach it in reference to the first Baraisa, where one entered the workshop of a carpenter. But the one who teaches it with regard to the first Baraisa of the carpenter teaches it only in reference to that Baraisa. But in this Baraisa of the welder, he is entirely exempt from liability for injury, as one could claim that he is completely blameless. That's what we've got tonight. Let me take a couple of questions and comments. On Bava Kamma 32. Joe, knowing that there are required Hanukkah lamps in the street, isn't the camel driver responsible to load his animals in a manner that would keep the product from burning? Yes, definitely at Hanukkah time you would say that, because the owners of the Hanukkah lamps are not going to be liable. So if it happens, so the question is, if the flax on the animal's back catches fire from the Hanukkah lamps, and we know the owner of the Hanukkah lamp is exempt, are we going to attach blame to the owner of the animal where the flax was overloaded and sticking out away from the animal? Or are we going to say that any fire that results is just a pure accident and it's too bad for the person who was the victim of the fire? Great question. You're suggesting, well, when you know that lamps are going to be out, the people loading the animals should be extra careful how they load the animals and how they walk the animals. Sounds reasonable to me. Not sure if that's the outcome, but it sounds reasonable to me. Bill, 13-year-old idiots. But you repeat yourself. This same joke works from ages 13 to 23 or thereabouts. Okay, fair enough on my story of running in the hallways. Sharon, is a person's honest remorse a consideration in determining of intent of type of killing? I don't know. That's a great question. I think we'll encounter, this body of law when we reach Tractate Sanhedrin and also Tractate Makos, right, on lashes. Because it sounds to me like, genuine remorse affects punishment, but does it change liability? I don't know. Why would genuine remorse affect liability? What it might be is evidence of what their state of mind was at the time the accident happened. And in that way, it might have a bearing on the outcome. And finally, Joseph, this kind of debate came up during the first year of the COVID outbreak. One has COVID in the public domain and may or may not be sick. If he knows he is sick, is he liable if another gets sick? Very good, right? So Joseph is saying, what kind of liability do you have based on what kind of negligence did you commit, right? If you didn't test yourself when you went out in public and you transmitted COVID because you didn't test, that will be different than somebody who is known to have COVID, but he went out in public anyway. And maybe he didn't wear a mask, or maybe he did. Maybe he sneezed, maybe he didn't. Maybe he had an emergency, maybe he did, right? You can see how the facts and the variations based on the changes in facts, can really multiply and affect the outcome in so many different ways. That's what I've got for us tonight. With God's help, we'll be together again tomorrow, regular time, 6 p.m. Pacific. And then tomorrow, I'm going to go live with you, teach the class, then we'll finish, God willing. And then just a few minutes later, I'm going to go live again. And I'm going to be telling 2 really colorful, entertaining stories of some Rebbes. One is the story of Rabbi Levi Yitzhak of Berditchev visiting the Shabbos table of Reb Baruch of Medjugorje. And the other one is the extremely dramatic, I mean, like a movie, tale of the persecution of the Savraner Rebbe, how the Savraner Rebbe persecuted Reb Nosson, who is really the person chiefly responsible for transmitting the teachings of Rebbe Nachman into the world. Two very colorful stories. That live broadcast tomorrow night is going to be at 7, God willing, and that's part of the Light of the Infinite Festival that I've been, invited to participate in. So I'll just be broadcasting live on our Facebook page, but that feed is going to be picked up and brought into this Light of the Infinite Festival, where they've got I think 20 speakers all, queued up tomorrow during the day. Pretty interesting. I think it's lightoftheinfinite.com. Maybe Nina put that link in the comments. I'm not sure. But I know that on our page, on Accidental Talmudist on Facebook, there is a blurb about the Light of the Infinite Festival. So tune in tomorrow night, starting at 7 after our regular class, which begins at 6. Have a great night.